Hello, my name is Olurotimi Osha. Today is August the 28th, 2026. Today I want to talk about the outcome of my case. I've long talked about how I was wrongfully charged in Montgomery County, Maryland. I've done videos discussing this. It's a case of prosecutorial misconduct and judicial misconduct and police misconduct, pivoting on subordination of perjury, fraud upon the court, and of course malicious prosecution. So I've done videos discussing that, but today what I want to do is talk about how a biased judge uh, through faulty, improper, and biased jury instructions was able to steer uh, the jury and coerce or manufacture a guilty verdict, violating my constitutional rights to a fair trial, an impartial jury, and of course an impartial judge. So the element of having an impartial judge, that's a 14th Amendment right, my due process of law. So this judge was biased. I'll do other videos explaining how Judge Michael McAuliffe of Montgomery County, Maryland, was biased, and he showed bias throughout. And I filed a motion, right, during the trial. I requested that he recuse himself, but due to his clear bias, right, he demonstrated that he was an advocate, a lawyer for the prosecution, right? He was an ally of the prosecution, an ally of the Montgomery County Police, who were the alleged victims. The Montgomery County Police, of course, were the ones who shot me in my home, came to my home without a warrant, and apparently trying to execute an emergency evaluation petition that was fabricated by a man called G.D. Wari. But Judge Michael McAuliffe, conveniently on behalf of the police and the state, removed all of these elements of the emergency evaluation petition. No warrant, by the way, no outstanding warrant for me, and I was in my home. So I'm just going to focus on the element of the coercive, biased jury instructions. Now, I'm also doing this video because my my family in Nigeria, my friends, they have concerns that following this guilty conviction, I'm awaiting sentencing, that the intention of Judge Michael McAuliffe and of course his accomplice Judge James Bonifant I've been talking about, it's like judges manufactured in Montgomery County, Maryland, manufactured this crime against me. They violated my human rights. Their out intent would be to have me killed, to stage a killing, maybe make it look like a suicide. We know those things are happening in America right now. And Maryland is the South. Montgomery County was a stronghold of the Ku Klux Klan. The Ku Klux Klan is said to have infiltrated the Montgomery County Police Department. So my family is very concerned. They're in Nigeria. The state of Maryland conjured up a perjurer, an impersonator, G.D. Wariri. I've done videos explaining all of this. Right now, I want to focus on the aspect of how Judge Michael McAuliffe steered a jury, right, to manufacture a wrongful guilty verdict, right, despite the insufficient evidence, but based on his faulty, improper, biased jury instructions. So, I gave objections throughout. So when the judge, after the evidence has been presented in a trial, the judge gives jury instructions, writes the jury instructions, and the attorney, the prosecution and the defense, right, I represented myself. I was forced by the judge to go pro se, despite my refusal to give up my right to my absolute right to the assistance of counsel. I did not voluntarily or knowingly or willingly give up my right to assistance of counsel. So I stated that for the record. That's a structural error, of course, in its own. I'm going to focus on the structural error of the biased jury instructions, right? So the judge then deliberates on jury instructions. So jury instructions would include three types of aspects of the law, three laws. They may include the procedural laws, the substantive laws, and the standard of proof, right? The standard of proof. So the procedural laws deal with how the jury assesses the excuse me, the credibility of witnesses and the types of evidence that was presented to them at trial. The substantive aspect of the law deals with the elements of the charged crime, right? The elements of the charged crime and the proposed defenses by the defendants against these elements. That's the substantive aspect. And then the standard of proof aspect deals with, in a criminal case, the standard of proof would be proof beyond a reasonable doubt, right? Proof beyond a reasonable doubt. So I'm going to focus in this video, I'm going to focus on the aspect of substantive laws, how Judge Michael McAuliffe failed to provide, sufficient substantive laws to define the features of the crime, and the law explain the laws and the defenses by the defendant, which I raised, right? I raised these defenses. So the charge was intent to frighten second-degree assault. I've done videos concerning this. I'm not going to go into the other aspects. Right now, what I want to do, as I said, is focus on the faulty jury instructions that were biased, that the judge provided to steer the jury. Eventually, the jury, after the trial ended on August the 5th, and the jury deliberated for 2 days. They were a hung jury. At the end of the day, he sent them home. So they went home, so they had time to access the internet. The prosecutor had time to convene with the juror. So that was prosecutorial and juror misconduct. The prosecutor was seen convening with a juror on August the 5th, right, 2026. So that's already that's already reason for the case for a mistrial to have been, for the judge to have ordered a mistrial. That was already sufficient. But again, I'm just going to focus on the faulty jury instructions in this video. So it took 2 days for them to deliberate. There was a hung jury. So the charged crime was intent to frighten. The judge, there were three cops who were the alleged victims. Coincidentally, these three cops were the cops who tased me multiple times, for at least 5 times. They were the 3 cops who tased me. None of them suffered a battery, right? So they claimed that I demonstrated intent to frighten second-degree assault. It's a misdemeanor in Maryland, but it carries a potential of 10 years maximum, right? Each one. So they could have, during the deliberations between the judge and the prosecution and the defendant, that's me, as I represented myself pro se. I was coerced by the judge to represent myself, as I said. I objected. I said that it should be one count. All of them should be combined in one count, because there was no distinguishing characteristics, evidence. There was no evidence that distinguished these 3, right? In fact, there were 40 people. So I said it should be one count. But the prosecution objected, saying, that it would be only fair to me if they make it 3. So they get 3 shots. They get to confuse the jurors 3 times, right? That was the problem, right? So I objected to that. So 3 of them, right? And then there are elements of the intent to frighten. So the judge failed to provide the proper jury instructions regarding intent to frighten. First of all, he mislabeled it as a general intent crime. I'm going to do a video explaining general intent versus specific intent, when in fact intent to frighten is a specific intent crime. By him labeling a misrepresenting it as a general intent crime, and that's what the prosecution did as well, which is bizarre because they're judges, they know the law. So there was intentional fraud by Judge Michael McAuliffe, right? Of course, and of course the state attorney, right, the prosecutor, by saying it was a general intent to frighten or a form of assault. It conflates it in the mind of the jury with a strict liability crime. A strict liability crime, mens rea, that's guilty mind, intent is not required, right? So that's one of the things. So recklessness is sufficient. They did something reckless, right? It's sufficient for, in their mind, again, because the jurors, again, are lay members. They don't know the law. They're from the community. So when he mislabels a specific intent crime as a general intent crime, it puts in their mind that, well, recklessness is sufficient, that whatever act they did voluntarily, they didn't really need the standard of mens rea, of guilty intent, guilty mind that's required in a specific intent crime. So in specific intent crime, mens rea, guilty intent, right? Intent is a required element. Now, furthermore, when the judge now gave the instructions on the elements of intent to frighten, he gave just 3 instead of 4. The elements of intent to frighten are 4, right? That's 4 standards. First, that the defendant committed an act, like a threatening act, an act intended to, put the alleged victim or someone, right, in fear of imminent, immediate bodily harm or offensive contact. That's one. Second, that they had the apparent ability, right, to carry out that harmful contact, right? Harmful contact, injurious contact, and it was immediate. They had the apparent ability to do so. The third element, that the alleged victim, right, had a reasonable fear. They had a reasonable fear that harmful contact, that harmful injury, contact or offensive contact would happen, that their fear was reasonable, right? And then the fourth element is that the defendant had no legal justification, in the law for their conduct, for their action. The judge did not mention the fourth element, that the defendant had no legal justification. So that's one. So that was a faulty jury instruction. It diluted the burden of proof of the prosecution, because the prosecution was required to prove all 4 elements together. By eliminating that fourth requirement, that no legal justification in the law, the prosecution didn't have to prove that. And then there are the defenses. You go to the defenses, proposed defenses. So, of course, I presented evidence, I made my arguments in court. They're defenses to intent to frighten assault, right? And I'll do another video to explain further, right? Because these are for instructional purposes. But I want to just immediately address what it was, the judicial misconduct perpetrated by Judge Michael McAuliffe, which denied me an impartial judge and an impartial jury. An impartial judge violated my 14th Amendment rights to due process, and an impartial jury, a lack of an impartial jury, violated my 6th Amendment rights to an impartial jury, right? So, sorry, with respect to an impartial judge, my right to an impartial judge, was a violation of my 14th Amendment rights, because Judge Michael McAuliffe was clearly biased throughout the trial. Now, in terms of the defenses, the legal justification that I had, Judge Michael McAuliffe removed the self-defense issue, right? I had an absolute right to self-defense because I was in my home. In the state of Maryland, there's a defense of habitation, a self-defense law. It's a right if one is in their home, and if there's an unlawful intruder, including a warrantless intruder, if it's a police and they have no warrant, they have no legal justification. In this case, the police had no warrant, right? It was made clear at trial that the police had no warrant. There was no prior warrant. In fact, during the trial, the judge intentionally, disingenuously made a statement that the police had a warrant, that they had a warrant, that they had a valid warrant, which was false. The prosecution corrected it that they had no prior warrant. They obtained a warrant after I'd been assaulted and removed from my home earlier, right? They removed me, assaulted me, falsely imprisoned me, and then assaulted me. And then they went to manufacture a false warrant. Those two warrants were were at trial. They were inadmissible, so all evidence should have been suppressed. I'll do another video on that, explaining. The detective Pack had a warrant that claimed I was in the home threatening my wife, and that Judge filed an emergency petition. Judge Michael McAuliffe prevented all mentions of an emergency evaluation petition, claiming that petition happened on May 14, and everything that had to do with May 14 he excluded, which biased me because that was exculpatory evidence. That's another issue. Brady Rule violation. I'll talk about that later. So all of this was inadmissible. But in any event, back to the jury instructions. So my defense, I had a defense of self-defense, right? Castle doctrine, right? Castle doctrine. So long as I'm not the initiator of aggression. I wasn't the initiator of aggression. The aggression started on May 14. I was a victim of a crime. In fact, the state of Maryland charged those two people, Jide Ware, with a crime, charged Germashumi, the neighbor he came with, attempting to kidnap me and assaulting me on May 14. And then they fabricated an emergency evaluation petition that Jide Ware since recounted. My family has proven that it was a fabrication. I've proven it was all a fabrication, right? So there was no probable cause. It was not a valid reason for them to come. By the way, the judge precluded it from being mentioned or presented at trial, right? So they had no legal justification for coming to my house. They had no arrest warrant, first of all. So it was an illegal intrusion. So I had a right to self-defense. By the way, even if it were an emergency evaluation petition, they're not under the law in Maryland. They're not supposed to use force against me, right? I have a right to defend myself against disproportionate force or unreasonable force that they're using. That's a part of self-defense laws with respect to emergency evaluation petition in Maryland. In fact, they're the ones who should be facing prosecution if they were executing an emergency evaluation petition, because they're not supposed to injure the evaluee. An emergency evaluation petition is not an arrest warrant. It is not a criminal charge. It's a civil matter that has to do with family. So this was actually sealed, because it was saying that my family wanted me to be taken to a hospital, right, for my welfare. That's what it was claiming. And all of this was excluded. But I ended up being injured. I suffered permanent nerve damage, permanent scarring. There are injuries all over my body. The judge did not want me to show all this evidence of how the police brutalized me. There are marks. I woke up with marks all over my body. The police had abused me. So Judge Michael McAuliffe hid evidence of police misconduct. But again, back to the jury instructions, focusing on how he provided faulty jury instructions. So he excluded self-defense initially. So he was doing something disingenuous, because he would present two documents. He would type them. He was typing the instructions, right? Discussing it with the prosecution and the defense. So he first included self-defense. Then the prosecution makes a show of an objection, saying disingenuously, falsely, that speciously saying that, well, that I did not raise self-defense as an issue. I raised it. I've written motions. I've raised self-defense, castle doctrine in all my motions, and I stated it at trial, right? So he made a false statement, false objection, and the judge excludes it, self-defense. Then another thing that I focused on was mistake of fact. I put it in a motion several motions I filed for motion to dismiss. I argued it in court. The judge first made a show of, well, he's going to include mistake of fact. Then again, the prosecution does that song and dance, does that pretense again, simulation, objection, right? Misinterpreting what mistake of fact was. And then the judge excludes mistake of fact. There was another thing that I was presenting, intoxicating. So another defense is if you were involuntarily covertly intoxicated, right? It negates intent. I made this throughout I stated this throughout in evidence at trial, but the judge would exclude it, say, oh, the jury should disregard it, that there's no expert witness. The expert witness I brought, right, who was a chemist of brain chemistry, specializes in these things, he refused to let him testify as an expert witness, saying I didn't include him earlier. That was one of the reasons why I had asked for my public defender to be struck, because 7 days to trial, she called no expert witnesses, even though I'd given her all of these names. She subpoenaed nobody. She just wanted to walk in there without any expert witness testimony, nothing, no witnesses, right? And that was what I went to go and report: ineffectiveness of the assistance of counsel, of my public defender, that they were sabotaging my case. They were just focusing on a plea bargain. The last plea bargain she offered was, if I go back to Nigeria and don't come back, they will dismiss the charges. I'm an American citizen. I want to prove my innocence. It's the burden of proof is actually on the state to prove that I'm guilty beyond a reasonable doubt. But I'm an American citizen. I haven't committed any crime. The state of Maryland, Montgomery County, the police, and Judge Bonifant, through his false incompetencies to stand trial orders, these biased, prejudicial incompetence to stand trial orders, defamed me. They damaged my reputation, and I wanted an opportunity to do that. And the trumped up charges against me, I was a victim of police assault, a first-degree police assault. And to add insult to injury, the police who assaulted me now said I was the one who assaulted them through an intent to frighten assault. But the judge now removed all defenses that I had. Right, mistake of fact was significant. The lack of capacity, lack of intent, right, due to involuntary drugging, involuntary intoxication of a drug, right? I had been drugged. I talked about it, that it was the effect of LSD and cocaine. They did it covertly. There was evidence of this. The judge tried to exclude all of that. So I had basically no defenses. No defenses at all to the intent to frighten. He removed all forms of defenses. By the way, his jury instructions also so confused the jury, because at one time, one of the questions he had was on first-degree assault. They thought I was being charged with first-degree assault. At another time, they deadlocked, and they said they couldn't deadlock. He had to give an Allen charge. An Allen charge is a dynamite charge. So the judge is basically coercing them that they have to have a verdict. They have to have a unanimous verdict. It was 2 days, right? So at some point they asked that, okay, that can they consider my state of mind, the state of mind of the defendant, my state of mind, as someone who was in a psychotic, like a psychotic episode. So they were hitting the nail on the head, even though he fails to give them the proper definition of intent. He didn't do that, right? He misrepresented intent as the actions that I demonstrate. He didn't talk about my guilty mind, the requirement to have mens rea, a guilty mind, right? Intent, and nor did he indicate defenses that can negate that guilty mind. So they asked that, can they assume that I was in some kind of episode, the psychotic episode? Under the law, right, if you're in a psychotic episode, severe episode, right, you can't form intent. So they were hitting the nail on their head. They were about to come with a not guilty verdict. He gave an answer that was tantamount to no, right? Because he didn't provide it in he intentionally left all of this, all of these definitions or explanation in his instructions. And less than an hour later, 30 minutes later, they came with a guilty verdict for one. So he coerced a guilty verdict. Judge Michael McAuliffe, through his faulty jury instructions, his biased jury instructions, manufactured a guilty verdict. If it could be done to me, I realize that there are several people in Maryland, in the state of Maryland, in Montgomery County specifically, and in the court of Judge Michael McAuliffe, who's biased, demonstrates bias against black men. And I stated in the court that the state of Maryland has the highest incarceration rate for black men. He refuted this in court at trial which was inaccurate. If you Google Montgomery, Maryland, you'll find that Maryland has the highest incarceration rate of black men in America. And that's because of corrupt judges like Michael McAuliffe, who steer juries by giving faulty, improper, and biased jury instructions, right? That dilute the burden of proof of the prosecution. So the prosecution has the burden of proof of proving beyond a reasonable doubt that all the elements, proving, using all the elements of the crime. In this case, intent to frighten. They have to prove all the elements exist beyond a reasonable doubt in the mind of the jurors. To the jurors, they have to prove that. The jurors who have to decide that evidence exists beyond a reasonable doubt, that the prosecution has proven their case. Not for me, the defendant, to prove my case. So Judge Michael McAuliffe misrepresented that burden of proof. He diluted that burden of proof by failing to provide defenses that I had. He didn't provide any defense. Instead, he gave something about character witness, that I wasn't, that my witnesses demonstrated that I didn't have the character to commit the crime. But that is not a defense. It's not an affirmative defense against the charges of intent to frighten. So basically, I had no defenses. I was just a sitting duck. By the way, I'll do another video explaining how the jury was already tainted. There were ex-cops on the jury, in the jury pool. There was a dispatcher. There were ex-cops in the jury pool. People, and of course the alleged victims were the police, were cops. So they favored those cops. The deliberations got violent. We could hear the white guy. There was a white guy who was shouting, screaming. You could see he coerced the man. He's the one who was an ex-cop. His brother was a cop. Their family were cops and things like that. I objected to the composition of the jury. I'm not trained in voir dire. I was forced to go through voir dire. Voir dire is jury selection, right? I didn't like the composition of the jury. In fact, I didn't like the venue. I requested a change of venue. All of this was denied because I was already told by my public defender that Montgomery County, the community favors the police. So I wouldn't have a fair trial, right? A jury would favor the police. So immediately I said, then we should change the venue. So all of this was against me, right? In the trial, it was biased, and of course, the burden of proof beyond a reasonable doubt. That's part of my Fifth Amendment rights, right? So the judge diluted that beyond a reasonable doubt. Fifth Amendment, an impartial jury, right? That's the Sixth Amendment. The judge violated that by giving them biased jury instructions, right? And then, of course, the 14th Amendment, due process, protects my right to an impartial decision maker, an impartial judge. But Judge Michael McAuliffe was not an impartial judge. By the way, he was scheduled and selected by Judge James Bonifant, a judge I had filed several judicial misconduct complaints against, who was under investigation for judicial misconduct in the proceedings during the pretrial part of the pretrial phase of the criminal proceedings, which of course based on trumped up charges against me. I'll do another video talking about evidence that should have been suppressed, which the judge inappropriately allowed the state to use against me. And of course he did not allow me to use exculpatory evidence. He excluded exculpatory evidence, including the fabricated emergency evaluation petition, including the fact that I was a victim of an assault, including the fact that the police filed false incident reports, and that the police actually manufactured the entire situation. They came to execute an which they had manufactured, right? And they entrapped me. They did things. They gaslighted me. They falsely imprisoned me. Blocked my peephole. All of that was exculpatory evidence, but the judge excluded that. So that falls under Brady rule violation. I'll do other videos just clarifying these elements of the biased nature of the case that I've just been wrongfully convicted of. My name's Olurotimi Osha. I'll keep you posted. Thank you.